Good evening, everybody. My name is Abhishek Ragor. I am a part of Royal Defence Academy, Jaipur. In yesterday's class, I have told you about Constitution. We have discussed various things regarding the Constitution, which I will be recapping today in 1 minute, 1 or 2 minutes. After that, I will be moving on to the next topic, important topic of Constitution, that is the fundamental rights, which comes under part 3 of the Constitution. I will be covering the whole of Constitution in subsequent lectures, but we will be moving forward with what is important and what is not in that order. Okay. So, in yesterday's class, we have discussed about what is a Constitution and what are the functions of the Constitution. Constitution is a basic document that defines how a country is going to be governed. Indian Constitution was implemented on 26 January 1950. As you must all be knowing, it was completed on 26th of November 1949. We celebrate Republic Day on 26th of January. In yesterday's class, we discussed that the Constitution of India has various functions. The first function of Constitution was to define the type of polity which India will be following. We are a democratic country, which means that our politicians are responsible to a larger electorate. We choose our MPs and MLAs and they represent us. They represent their constituencies. After that, they get the power to make laws. They sit in the legislature and elect laws. Through these laws, we are governed. This type of polity is a democratic polity. This is also mentioned in our Constitution. Another function of Constitution is to determine the form of government. As you all know, we follow the prime ministerial form of government, which is also called as the Westminster form of government, which we have followed from the United Kingdom. In parliamentary form of government, also called as the prime ministerial form of government, there are two houses, Lok Sabha and Rajya Sabha, and the government and the political party or the coalition of political parties which get a majority in the lower house are able to form the government, and the prime minister is selected from prime minister as the leader of that grouping, that coalition. So we follow the parliamentary form of government. Apart from it, Constitution also mentions that India is a federal country, or more particularly, India is a quasi-federal country according to some constitutional experts. Article 1 of Constitution clearly states that India is a union of states. It means that India has various states and the power is divided between states and central government. For example, at the central level we have the Prime Minister, but at the state level we also have a Chief Minister. We have the President at central level, but we also have governors in respective states at state level. We have the Parliament, that is Lok Sabha, Rajya Sabha and the President at central level, but we also have the state legislative assemblies at the state level. This is the meaning of federalism. But here the question arises, what is the meaning of the word quasi-federal? Quasi-federal. The word quasi-federal implies that Indian federalism has a strong tilt towards the centralizing tendencies. It means that India's democratic polity, the central government is more powerful as compared to the state government. Let me give you some examples. The central government and particularly the President has the power to dismiss the state government at any point of time according to Article 352 to 360. You must have heard about the concept of national emergency and financial emergency and also the governor's rule, the President's rule. These are all the mechanisms which implies that India has a strong centralizing tendency. Moreover, the tax collection power is more with the central government as compared to the state government. And there are various other things which makes India a quasi-federal country or a federalism with a strong centralizing tilt. After that, we also discussed the functions of Constitution, where I told you that the Constitution also gives certain rights to the citizens. These rights which are mentioned in the Constitution are of two types. The first is the fundamental rights which are mentioned in the part 3 of the Constitution. We will be discussing about fundamental rights today itself in today's lecture. The second is the constitutional rights which are given not in part 3 but in other parts of the Constitution. We will be discussing about the other constitutional rights also. So moving forward with today's topic, that is fundamental rights. This is the most important part of the Constitution. The fundamental rights are mentioned in part 3. Our Constitution is divided into various parts, largely 22 parts. Part 3 deals with the fundamental rights. These rights are fundamental in nature. It means that the fundamental rights are most important rights given by the Constitution to its citizens. The fundamental rights are guaranteed by the Constitution. They are mentioned in part 3 of the Constitution. The fundamental rights given to the citizen are a protection against the government's infringement, state infringement. This means that the government cannot violate your rights, your fundamental rights which are given in the Constitution. If you think that your right has been violated by government of India or the government of any state or the government of any union territory, then you can directly go to court. You can directly go to even Supreme Court of India under Article 32 and you can plead to the Supreme Court that my fundamental right has been violated. Please give me a solution. Next. Something more about fundamental rights. What is the importance of fundamental rights? The fundamental rights protect the individual liberty of an individual. As you know, human beings are the most mature beings on planet Earth. They have the wisdom. But in order to fully utilize this wisdom, it is very important that liberty is granted to that particular human being. If a human being is not granted a liberty, is not granted freedom, is not granted equality, then that particular human being will not be able to utilize its potential to the full extent. So the fundamental rights ensure the protection of individual liberties. They protect the individual from encroachment of their rights by the state or any other individual. The second important feature of fundamental right is the foundation of a just society. Just society meaning there is a justice in that society. Justice can be social, political or economic justice. Justice implies that every person in a society has equal chances, has a liberty. There is no discrimination among individuals in that society. There is a freedom of thought, religion, expression, faith, worship in that society. All of these things makes a society just. There is no authoritarian tendencies in that society. We see in present circumstances the countries like North Korea etc. which are not just societies. They are highly unequal societies. Their polity is dictatorial polity. There are no rights to individuals. But in our country, India, the fundamental rights ensure that our society remains a just society. The next is promotion of equality and justice. The fundamental rights also talks about the right to equality and justice. What is the meaning of the term equality? It basically implies that there is no discrimination by the state or by the government among few individuals, or there is no special privilege given to certain section of individual. There is no special treatment given to anyone. All the citizens of this country are equal in the eyes of law. This is the meaning of equality. And you must also be knowing the meaning of justice, which I have already discussed. Next. So there are various types of fundamental rights which are grouped. First, we will be discussing about the right to equality, which are mentioned from Article 14 to 18. Article 14 talks about equality before law and equal protection of law. We will be discussing about Article 14 in detail, but let me summarize these 4 articles for you. Article 15 talks about the prohibition of discrimination. Article 16 talks about equality of opportunity in the matters of public employment with regards to jobs, especially the government jobs. There is an equality of opportunity in government jobs for everyone. Article 17 talks about abolition of untouchability. We are going to discuss about this in detail. Article 17. Article 18 talks about abolition of titles. There are various titles given by the government, central government. For example, Bharat Ratna, Padma Vibhushan, Padma Bhushan, etc. We will be discussing about these also. So these are 5 articles. So first we will be discussing about Article 14 before moving forward to Article 15. Article 14 basically implies the right to equality and equal protection of law. There are 2 different terms: right to equality and equal protection of law. Right to equality means all citizens in the country are equal in the eyes of law. This is the meaning of equality. There cannot be any discrimination on the basis of religion, race, caste, sex, place of birth, etc. The state cannot differentiate between these grounds, among these grounds. The second term which arises is the equal protection of law. But as you must have observed that there are already some sections of Indian society which are weaker sections. These are scheduled caste, scheduled tribe and other weaker section. So if the principle of equality in Article 14 is applied, then the rich person will be treated equally in the same way as a scheduled caste or scheduled tribe person or other backward class person. If that is the case, then we will not be able to uplift that SC, ST person or other weaker section person if he is treated equally with the rich people. So there is a need for special treatment for these people, that is the scheduled caste, the scheduled tribe and other weaker sections. This is the meaning of equal protection of law. Equal protection of law implies that if there are certain weaker sections in the society that demands more protection as compared to the other uplifted sections of the society, so we have to give them special treatment. This is the meaning of equal protection of law. One of the prime example of equal protection of law is the concept of reservation. The scheduled caste, scheduled tribes and the OBCs are given certain reservation in jobs and education. This is the example of equal protection of law. Though it appears that it violates the Article 14's right to equality concept, but actually it strengthens the right to equality concept and does not violate it. If we give the equal protection of law to certain section of society, for example SC, STs, then we will be able to make our society an egalitarian society. Okay, in this way we will be able to uplift SCs, STs and OBCs to the level to which other uplifted section of the society enjoys. So equal protection of law is a very important concept that is being also followed in United States of America also. There is also a concept of reservation for blacks in USA. We also follow this system. Now coming forward, with Article 15 back. Prohibition of discrimination. Article 15. Article 15 states that the state cannot discriminate with its citizen only on the grounds of religion, race, caste, sex, place of birth, with respect to the access to the public places, shops, restaurants, wells, bathing ghats and other places of public entertainment and resorts. Not just the state, but the private citizen also cannot discriminate among human beings on the grounds of these religion, race, caste, sex, place of birth. With respect to, there are certain places which are identified by the Constitution. There cannot be any discrimination in public places, shops, restaurants, well, bathing ghats, other places, etc. Let me give you an example. If a rich person or a poor person goes to a hospital, the hospital cannot deny admission of a patient in its hospital for a poor person just because he is poor, or just because he is from different religion, or just because he is from different race, he is from different caste, he is from different sex, he has a different place of birth. If a hospital does it, then he has violated that individual's fundamental rights, and that individual can go to court to seek remedy. The next is, under Article 51, we also find the concept of reservation. Article 51 talks about the special provisions for SCs, STs, economically weaker section and women. The state can employ certain methods to protect scheduled caste, scheduled tribe and economically weaker section. So the concept of reservation finds its roots in Article 15 of the Constitution. It also finds its roots indirectly in Article 14 under equal protection of law, but more specifically Article 15(3). Article 15(3) directs the central government to take special measures for the protection and upliftment of women. Article 15(4) Article 15(4) of the Constitution, which was added by first constitutional amendment, it directs the state to take special provisions for the protection of scheduled caste, scheduled tribe and other weaker sections of the society. So we find the mention of the concept of reservation in these articles. Next. The next is equality of opportunity in public employment. Article 16. As Article 15 told about the prohibition of discrimination, this article is specifically related to reservation and the equality with respect to the public employment. As we know that state cannot discriminate only on the grounds of religion, race, caste, sex, descent, place of birth, etc. or any of them. The state has to provide equal opportunities to all in the matters related to the public employment or the jobs under the state or center. The equal opportunity concept implies that there are certain sections of the society that are not equally placed with respect to other sections of the society. So the state government or the central government has to reserve certain seats so that the equal opportunity can be provided to these particular sections of the society. For example, there are seats reserved for scheduled caste and scheduled tribe in the matters of public employment so that they can get equal representation. You will not believe that there are certain parts of India which do not even know certain various posts. For example, Patwari or collector, they have not heard about these posts. Forget about applying for these posts. They do not know what these positions do, how they affect them. So it is very important for the government to reserve certain percentage of seats so that these scheduled caste and scheduled tribe people can be represented in these public employment offices in our country. The same thing which I have talked, the reservation for SCs, STs and OBCs. The fourth is special provision for backward classes is also mentioned under Article 16 of the Constitution. There are different articles for scheduled caste and scheduled tribe, and there is different article for the backward classes, other backward classes. But the concept of reservation for public employment find it mentioned for all the segment of the society in Article 16. Next. Article 17 talks about the abolition of untouchability. All of you must have read something about untouchability. You must be knowing something about untouchability, in my opinion. Historically, there are a few segments of society, Indian society, which have been discriminated by a huge extent. For example, certain sections of the society were not allowed to go to temples. Certain people in our Indian society historically were not allowed to touch the persons of higher caste. These peoples were also subjected to residence outside the village area. They could not make their home in the center of the village or nearby temples. They were segregated from the village. They were not allowed to eat with the people of higher caste, so-called higher caste. So these were the historical injustices that was done to them. Okay, but in 1947 we became independent, and in 1950 we adopted a democratic polity and a democratic constitution where the rights of each individual was secured and protected. So these societies, these segment of people which were discriminated historically demanded certain protection. These were the people which we have given the concept of reservation. The reservation has been given to them to uplift them. There is also an abolition of untouchability. The untouchability practices include all of these practices which I have mentioned here, these four practices. That is, they were not allowed to go to temples, they were not allowed to touch higher caste people, they were not allowed to reside out in the village area, they were forced to reside outside, and they were forced to do menial jobs. They were not allowed the regular type of employment which was done by other segment of the society. They were also not allowed to eat with the people of other caste. So this was the historical injustice that was done to them. But thankfully, to make our society an egalitarian society, an equal society, Article 17 have been introduced which bans untouchability. There is an abolition of untouchability through Article 17 of the Constitution. All these practices that I have mentioned earlier are banned according to the Constitution of India. If someone found indulging in these practices is punishable for violation of these fundamental rights.